Bienvenidos y bienvenidas a este evento por parte del grupo EU-LAC.
Welcome everyone on behalf of this event, on behalf of the EU-LAC Group, a network of NGOs working on the situation of Latin America and advocacy of the European Union. My name is Alice Coy. I work with Corpus Christi International and I'm the chair for this event. Before anything else, I'd like to remind you that we have interpretation into English and Spanish, and you can choose which language you want to listen to, clicking on the globe, an interpretation globe at the bottom of your screen. We are organizing this webinar to organize recommendations for the European Union institutions regarding access to justice and reparation in the framework of the new legal proposal regarding diligence for companies in the field of human rights and the environment. A very important aspect is to have a look at the Latin American context, because the private sector, including European transnational companies, have led activities in certain sectors that have weakened the environment in the region and led to human rights violations. In most cases, not justice, not reparation, is found for the people and communities affected. The proposal of the European Union is going to be published by the Commission, and it will be discussed by the European Parliament and the Council through its ordinary legal process. So this is a very timely moment to organize this event and reflect upon this crucial matter. I'm going to explain how this is going to work. First, we will have an introduction of this new act by MEP Mr. Pascal Durand, and then we'll have the presentations of three representatives of institutions and civil organizations from Latin America, and then we will have an exchange with two MEPs. After that, we have a Q&A session with the participants, and then we will finish with some recommendations from the EU-LAC group. My dear colleague, Alba Gonzalez from Solidar, will look after the time. She will be the timekeeper, and she will announce when you have a minute left. During the event, you may ask questions through the Q&A feature or Facebook of EU-LAC and also of the Heinrich-Böll-Stiftung. We will collect them and discuss them during the Q&A as much as we can. The chat function is not working. I would like to inform you that this is being recorded so that we can then have it on YouTube. Let us then begin with the event. I will first introduce Pascal Durand. He is an MEP from Renew Europe, the European Parliament. Pascal is a French lawyer, and in 2008 he co-founded the political party Europe Ecology, the Greens, and he led the campaign for the European elections in 2009. He's the Secretary General of the party. He was Secretary General, and in 2012-2013, and he was chosen as an MEP in 2014. He's been involved in public transparency, the fight against tax evasion, trade secrecy, and the protection of whistleblowers. He was elected an MEP in May 2019, and he is part of the Renaissance Group. He is now part of Renew Europe, and he supports the causes related to the ecology, transparency, and animal welfare. And what's more important for this event is that he has been one of the spokespersons for the legal act, for the report for this act on due diligence and the accountability of companies. So, Pascal, could you introduce the new act and the legal process and the discussions that have taken place at the European Parliament, and how we could incorporate justice and reparation for victims in the legislation? You have the floor now.
Okay, thank you very much. Of course, I will thank you for inviting me today on this webinar. And it's a crucial topic, of course, of protecting human rights defenders. And I think it's absolutely major, and it's too often overlooked under European Union in order not to harm our trade. It's the reality. Yet we have known for decades, since the assassination of Chico Mendes, that one can lose her life in Latin America for defending indigenous population, their habitat, lands, forests, and biodiversity. You know better than me this report published by Global Witness in September, recalling that 227 activists were assassinated in 2020, and the majority of them in Latin America. So we know that these people were killed because they opposed powerful industries that profit from the exploitation and export of products like, I don't know, soybeans, meat, cocoa, or minerals to our European market. So this means that the EU, if it does not want to remain complicit of these atrocious crimes, has a duty to act. But how can we act? By dealing with the problem across the entire chain, from the root, the place of production, to the end, the purchase of import products. Firstly, Europeans can act by not buying these products or by buying fair trade and sustainable products. But that means putting the responsibility on every household and only on European citizens. So secondly, by not signing free trade agreements, you talk about that do not have enforceable environmental and social guarantees. The problem is that even if we do not sign these agreements, many goods are still traded across the Atlantic, of course, and we are faced with great difficulty in acting against governments complicit of this exploitation, such as the one of Bolsonaro in Brazil. Thirdly, and in my opinion, the best solution, which does not prevent from using the ones previously mentioned, by targeting economic operators and by putting in place compulsory European legislation on due diligence, which allows NGOs and representatives of socially exploited local population to access European justice. This is the solution the European Parliament has been working on for over a year. In a report adopted in March, of which was one of the negotiators, the European Parliament called for the introduction of a due diligence obligations for companies in order to prevent and address negative impacts on human rights, the environment, and good governance throughout their subcontracting chain. It states that companies must ensure that their purchasing policies do not cause or contribute to potential or negative impacts. The report highlights the role of value chain, manning, and disclosure so that companies can better identify their business relationship and recommend disclosure requirements regarding the company's due diligence strategy. The report also provides for the competent authorities to undertake investigation or their own initiative or following complaints and impose fines and other administrative penalties. It's also called on member states to ensure that a civil liability regime is put in place to hold companies accountable and remediate the damage caused to people and the planet. The last part on accountability is, of course, of crucial importance for human rights defenders, as due diligence will not have much effect if companies are not held accountable. As a result, civil liability is also the part against which the private sector lobbies the most, of course, as we parliamentarians wait for the Commission to come up with a new legislation. This new legislation will be a directive on sustainable corporate governance, which will include due diligence requirements, as announced by Justice Commissioner Didier Reynders last year. This directive was, however, delayed due to intense lobbying efforts by the industry. We now hope that the proposal will be published by the end of the year, and that it will send a message of humanity in defense of living things, to climate, and the dignity and right of millions of people on this planet who do not have access to the most basic care, who do not have access to justice, but who provide us with their workforce and their lives. So we hope that will change soon.
Thank you so much, Pascal, for your presentation. I will now switch to Spanish.
Okay, let me continue in Spanish now. Thank you so much for the presentation. It is a shame to hear that the directive, the draft, was delayed, and that, as you were saying, it was mainly due to the lobbies by the industry. And we know that yourselves, the EU-LAC group, and a lot of people who are taking part in this event are ready to work on the matter and see the draft and work on the draft. What I think is interesting, if going back to the report you mentioned, is that in your report, the European Parliament, you mentioned that we need to have the member states as well taking responsibility, and that they can listen to claims and complaints, and that they can introduce sanctions. And this is important in terms of reparation, justice and reparation, and also civil liability, as you were mentioning. Another interesting aspect you mentioned are trade agreements. I think that this is a topic that we will be discussing during this event, and it's one of the recommendations of the EU-LAC group to address these problems. Whenever we speak about due diligence and legislation about this, this is an important topic. We know that you're very busy today with different parliamentary activities, so we would like to thank you for being with us. Thank you for your presentation. We know that you have to leave early, but we are very grateful that you were here to present the initiative. We'll now give the floor to our next speaker, a different speaker, a distinguished speaker now. We will now be listening to Soledad García Muñoz, who is a special rapporteur on economic, social, cultural, and environmental rights of the Inter-American Human Rights Commission. Soledad is a feminist lawyer, and she has much experience at both national and international court cases. She is also a professor in different universities. She was the president of Amnesty International Argentina, and she is a prestigious consultant in prestigious study centers at both national and international level, including several UN agencies. So Soledad, which are the most important hindrances and obstacles that you find in Latin America regarding justice and reparation for victims of human rights violations by companies? If we look at your latest report on companies' human rights and inter-American standards, what can we take into account for this new European legislation? You have the floor now. Thank you so much, Alice. My greetings to you all. I'd like to thank you for the invitation and for the opportunity to be here with you today and be part of this discussion panel on a topic that's so relevant for me and for the well-being of the peoples of Latin America and the Caribbean, as you were saying, and the Special Rapporteur on Economic, Social, and Cultural and Environmental Rights of the Inter-American Commission on Human Rights. And this is a new mandate. It was created 4 years ago. And the Inter-American Commission on Human Rights entrusted this topic of companies and human rights to me. And we've been working for quite some time since the mandate was created. And we prepared a report. I'm very glad that you mentioned it, because the report provides several answers to your questions. This is a report, specific report on the topic, and it, of course, considers the progress that has been made at the universal system and the guiding principles, initiative for a binding treaty, and other developments. And it brings a context to it in Latin America and in an inter-American context, including Latin America and the Caribbean. We've identified several obstacles in order to access justice and reparation by victims of violations of human rights in the context of business activities. In the report, we also state quite clearly what the duties are of states, of both American states in this matter, and we introduce a principle and a duty that brings extraterritoriality in question. This is an important matter we need to consider, and an important matter that we need to include in the efforts that are making the developments that are happening in Europe. We are paying close attention to this because they can make a difference in order to reduce the obstacles and to provide access to systematic reparation procedures for victims of human rights violations. Our research and also the guarantee to access reparation mechanisms are not just words, they're duties that states have within the duty to ensure the rights of people in the framework of business activities or corporate activities. However, in our report and our studies, we see that through many meetings with civil society organizations in the region, we find many obstacles to access justice and reparation. To summarize, some of the obstacles are structural, some of them have to do with inequality in our regions. Our region is the most unequal on the planet. And as the previous speaker was mentioning, people, human rights defenders against mega projects, against some corporations, very powerful corporations, they run great risks. And as the Global Witness Report said, our region is the most dangerous for environmental activists. We also find obstacles in terms of institutional weakness in our states. And this leads to impunity in terms of lack of access to justice and lack of access to reparation. And there's also an asymmetry in terms of justice administration that's generated between the victims and the companies, especially when we speak about large companies, companies that are very powerful. We also find some structural aspects that hinder access to justice and reparation, such as, for example, the economic policies that are following an extractivist model in a region. In 2015, our commission drafted an important report regarding extraction industries, indigenous peoples, and Black communities in our region, and how important it was to understand, both in the region and in the world, that we move from an extractivist model and a model that has economic growth as an end in itself to a model in which human rights are at the core, at the center. This is one of the obstacles we find in our region. I think that this is an obstacle, a global obstacle, that this paradigm of companies and human rights has to be there to replace this other model with corporate social responsibility model is quite recent. Some of them is just 10 years ago. Our theme-based report is only 2 years ago, while the defense of human rights defenders in the face of abuses of companies is long-lived, and the legal developments or plans and companies and human rights, the standards of a working group on companies and human rights at the UN are all recent developments. That's why we have no time to lose, and that's why we really need to have this topic the spotlight and focus on the second on human rights. And the second part of the question about the report and how it can contribute to the process of the EU, I think this report is key, especially because the process at EU level is very important to improve the lives of communities that are vulnerable at this moment and who lack access to justice and reparation in terms of violations committed by European companies. In our report, we established the inter-American criteria in terms of core companies and human rights that any company operating in the region has to take into consideration. For example, the person and human dignity has to be at the center, prevention and due diligence have to be included. This is a European initiative that has to do with due diligence that we're discussing, and due diligence is a standard that the inter-American human rights system has developed as I think in the best way in the world, because in the first sentences of the court, they used due diligence, and they claimed the due diligence means that the state has to organize everything so that human rights are exercised and are guaranteed. So this is what I would tell those who are working at European level, that they use and they update the European apparatus to guarantee that human rights are included in the context of business activities of European companies, that they are guaranteed and that our standards are complied with. And of course, we're there for you. We're from my position. We're here to support you in whatever you need beyond today. I'm sure that we can contribute. We hope that we can contribute to this process, and we hope that despite the lobbies that were mentioned before by Pascal Durand, that we can make progress, because this is, in fact, an urgent matter. We need to do it now. We need to have more tools, effective tools, to guarantee access to justice and reparation, especially for vulnerable groups in the Americas. And our report speaks about this. And I'll leave it here. If you have some more questions, but I'll be happy to answer them. Thank you very much.
Muchas gracias, Soledad.
Thank you very much. Thank you very much, Soledad. I love the fact that you mentioned what we can learn from the inter-American system, the fact that you have so much experience around due diligence. And you also mentioned the recent report published by this organization. We've published the link to this report in the chat box, so you can all access it. Indeed, there are many experiences in Latin America around this subject, and I hope that many of you here can access this report and learn about the inter-American work that's being carried out. Thank you very much, Soledad. We will now continue with our next speaker. His name is Juan Carlos Flores. He defends human rights and he works in Mexico. Juan Carlos is a lawyer and he's a member of People's Front in Defense of the Land and Water. Morelos, Flax, and Cala. I'm not sure if I've pronounced it well. Otherwise, please correct me, Juan Carlos. He was detained in a previous project, and for that he was taken to prison in the year 2014. Juan Carlos, can you tell us what are the main problems of the communities you're working with in terms of access to justice and reparation? I wonder what should be included in the new EU legislation so that these communities have access to justice and reparation. You have the floor. Thank you very much, Alicia. Thank you. It is an honor for me to share this roundtable with all of you, and especially if it's all about discussing all these very important subject matters for everyone worldwide, and especially here, you know, the impact of mega projects in communities around the context of the EU wanting to eradicate all these situations of violence and injustice. In relation to your first question, the criteria to access to justice in mega projects, it depends on the dimensions of the mega project and the political and economic interests that are behind it. Sometimes in the case of an average project, we have been recognized the right to recovery and reparation, but in the Integral Moreno's project, for example, there have no rights recognized. The indigenous have not been considered the legitimate owners of the territory. And then there are many projects linked to the implementation of a large project in a special area in Mexico. There are no special technicians that are expert in the recognized areas, and in general, there are no specialists coming out of universities. All reports are not being published, and if projects are not being complex, and in order to analyze the impacts, we do need specialists, strong specialists, and we are lacking these experts in our legal system. For example, in the Integral Moreno's project, it is a high-risk area. We've asked for the specific reports, but these have not been submitted yet. And then there is the issue of recovery when indigenous projects require the suspension of a mega project because they have not been informed. Lawyers basically think that the communities, in order to receive suspension, must make sure that the suspension does not affect the social order, and they need to have a social interest tag that has to link the project with an interest. So all of this implies that mega projects are often not being suspended. The access of justice on the parts of people, while people defend themselves in different ways, in social ways, and in the Project Integral Morelos, for example, and as in many other examples in Latin America, as it has been mentioned, this has implied the killing or the torture of one of my colleagues, and also the murder of one of our colleagues. It is a reality that affects many communities, despite many suspensions, such as what's happening in our case. We have many suspensions linked to an aqueduct, this mega project that's being implemented. The company is basically overlooking the suspension. So these are realities at national level, but when we jump to the international level, you know, very often what's happening is the money that's being injected to the process. Well, it's a fund that belongs to the Ministry of Economics, and it basically states that funds, that projects cannot imply infringement of human rights. But what we are seeing is that very often we see that there are no mechanisms to open grievance complaints when there's been grievances of different kinds. Then we also should also highlight, in the case of this project, you know, very often it happens that many of these projects are redundant, so there is no further need for the creation of electric plants. And so basically that is the overall point I'm trying to convey in relation to the due diligence project in the EU. I think it is essential that the legislation introduces mechanisms that demand and guarantee the access of justice and human rights to indigenous communities in Latin America. It is fundamental that one can open a complaint case with the EU in the case of violations of rights with indigenous communities in Latin America. This due diligence project should make sure that different European courts are aware of this subject matter, are very also aware of the incidence of projects within communities. It is essential that this law prohibits certain extraction mechanisms that are high impact. Each member of the EU should also make sure that the different credits from different companies should be supervised, and the self-determination rights of indigenous people should be protected. So what is happening between the FIEPs and the Spanish state is not repeated. There should be also express recognition of the rights of indigenous people to self-determination. In this sense, the EU could well carry out this law, and a self-determination principle should be guaranteed, especially in the case of mega projects, where very often there are infringements of human rights which are resulting into different grievance mechanisms. Countries such as Mexico, Colombia, and other Latin American countries have clauses that defend indigenous communities. There should be a harmonization between these clauses and the international alliances. Then we should also promote a creation of a network of lawyers that defend indigenous communities. The access to justice of indigenous communities requires the obligation to comply with certain laws on the part of multinationals and big companies. It is essential that indigenous communities accept that certain projects be carried out in countries such as Mexico. Indigenous communities it should be guaranteed that the rights of the indigenous communities are guaranteed. One of the specific measures to guarantee that should be guaranteed in the Mexican legislation is that these permits to mega projects includes the suspension of plans as it applies in the case of agrarian projects. So subjects of indigenous rights and the agrarian project should be made equal at this level. And then there are other topics around that, but I have no time, so I'll leave it at this. Thank you, Juan Carlos. I think you covered very important topics for the new diligence project, and I hope that there are many people in this meeting that are listening to what you said, because you are very right. people and affected communities should have a voice, and the fact that there are mechanisms and instruments for justice and reparation, both in the EU but also in Latin America, is crucial because there are many structural problems. You mentioned many of them. I also want to say that you are a very courageous colleague, as many of your colleagues in the EU-LAC group, and I hope that we can support you from here with our work. Thank you very much. We will now continue our panel with a speaker from Colombia. Good morning, Colombia. I'd like to introduce you to Laura Montaño. She's a member of the Colombian Roundtable on Businesses and Human Rights. Laura is a lawyer and she has a master's in applied economics from the Andes University. She's a researcher in the area of financing of the environment and human rights. And, she is well versed on environmental law, admin law, constitutional law, national policies, organizations, and projects. For the past 3 years, she's a member of the mentioned roundtable. Laura, how can the new EU legislation make sure that the human rights and business principles are complied with in Colombia, and how can we move to a national plan? I'll give you the floor. Thank you very much. Good morning, everyone. My name is Laura Montaño. As my colleague mentioned, I work on environmental rights and also human rights in an NGO from Colombia that works on environmental issues in Colombia. We are part of the roundtable on business and human rights in Colombia, and today I am here as a representative of that roundtable. I'll tell you a little bit about the roundtable first, and then we can move on to questions and answers so that you know what we do. The roundtable is an autonomous roundtable covering different NGOs and different environmental organizations, academic groups, international organizations, which are often observers, and so on. And we carry out debates, learning experiences, and shared proposals around a critical analysis of business practices in Colombia. This initiative was started off in the year 2016. We've had different courses of action to carry out our objectives, which are research, strengthening of organizations, personal accompaniment of people in their own territories, incidents in lobbying in national and international arenas, and also support in legal courts in the cases of human rights and business rights. We have had to position ourselves in different situations in Colombia through pronouncements. There was one particular instance in Colombia which was very much in the news. We've done pronouncements around the attitude of the government in the area of human rights. We did a particular declaration on the behavior of companies and the government around the lockdowns and the different measures in 2020. We also published comments on on the binding treaties to companies. We basically aim at strengthening the standards on businesses and human rights in Colombia. We have currently placed ourselves as an important actor in this arena, and we want to be a reference within civil society to conduct a national network around businesses and the other great pillars that we work on. And in order to answer the question, so first of all, I'd like to talk about the general situation in Colombia around businesses and then mention how this new due diligence project could have an impact on what we do. First of all, in Colombia, as a government and state, we have recently published the guiding principles, and we are one of the main first countries in Latin America to have its own plan on businesses and human rights. So we have high standards to start with. However, the situation in Colombia in the area of human rights is alarming. On the one hand, the defenders of human rights and the environment find themselves in an extremely delicate situation. Recently, there's also been instances of corruption with different third parties. As a country, we have different human rights treaties that have been ratified. We also have a national plan that's been established. We've had two other plans. The first one was in the year 2015, and then we issued a new one last year in the year 2020. But this content does not constitute a real strategy for the government because it does not lay down a preventive approach to human rights, for example, and this context where there's a lot of rules but little execution or implementation puts itself in an alarm situation because in the past few years we've realized that it is important to go headfirst into this really complex situation.
Since 2016 and since 2019, we're still the first country in the murder of environmental leaders, and we're well ahead of other countries, as we saw in the Global Witness report. The first one is Colombia, usually the second one is the Philippines, and the difference in numbers is quite big, from 60 to 20, for example. So Colombia is 3 times higher than the second behind it in the world. For example, on the 14th of September, we had 116 murders of social and environmental leaders just for 2021. Many of these people, as Juan Carlos was mentioning, and Soledad were mentioning, are people who were presenting complaints in terms of human rights violations by companies and their business activities. And therefore, the situation of vulnerability after these claims, first because they complain against companies or projects, and the concept of global environment and global development in which these companies are working is what endangers them. That's the first thing. Secondly, we're also in a moment of a backlash and affecting environmental and social policies that was deeply affected by the pandemic. How? Because the business sector is now putting a lot of pressure to lower environmental standards, social standards, because as they say, they have to ease up procedures. And this is a shock already. It's a clash of understandings. The tools they have, for example, business groups have supported express environmental reports, less than 12 months to be done, and virtual meetings, regardless of the fact that in the Colombian Amazon, people do not have access to internet. They also lower transparency standards for environmental movements. And a couple of years ago, around 2017, there was a strong lobby to be excluded from the peace standards and the peace agreements in Colombia. So they do not have to appear in front of peace courts as implicated. They can do it voluntarily, but there's no duty for that. Then, if we look at lockdowns in 2020, we've had many violations of labor rights and trade union rights, for example, with mass layoffs, and also an extractivist context without having necessary measurements for biosecurity. So they were forced to go back to work without knowing what kind of protection and standards were going to be applied. You have a minute left. Just give me 2, sorry. Yes, 2. So during lockdowns in 2020, 2021, we saw that there was a higher criminalization of social protest by companies. This is the context. And now let me go even faster into the keys of the due diligence legislation for the Latin American context and Colombia in particular. First, the appearance of a new state actor in social environmental conflicts with companies. This is a new space for claim and advocacy and human rights violations that does not depend from the economic interests of the Colombian state. And therefore, this creates a protection space for human rights and environmental defenders for external complaints, because complaints in our countries are highly dangerous for these people. So we can have international action taken where there can be actual means to take them to court, but it helps them be anonymous in their own country, but facilitating access to claims internationally. And I'd like to highlight that within the directive, we hear that these complaints should not restrict access at local level. And there are many reparation mechanisms where they ask them to give up local reparation mechanisms if they apply to the other ones. Another key in this law is that the standards that the European Union would impose on companies could directly or indirectly strengthen territorial processes in Colombia. One of the cases we're thinking about in terms of transparency and information standards. Accessing information in Latin America is quite complicated because the institutions do not deliver information neither to companies, but in a context in which we can get this from third parties, for example, institutions, the EU or the member states will help us check that information with the information we have at national level and at local level. This helps strengthen our territorial processes. Another aspect I'd like to underline is that accessing information is one of the first steps to ensure environmental and social justice. And I'd like to underline that justice cannot be thought after the fact. It cannot be just something that happens after the fact, but in human rights, justice has to be preventive, and in extraordinary cases, it has to include reparation. And reparation should be the exception because business activities should not go into human rights violations. Everything should be done preventively. We should never wait until a violation has happened. The third aspect, and I will close it here, and I apologize for speaking for a couple of minutes longer than expected, is that this legislation should have a domino effect. Therefore, when these large companies and large markets in the world, when they see that the end consumer wants to have those robust standards, the companies can go into the supply chain, regardless of the other measures that we can apply. This is going to have an effect. Why? Because in a scenario in which local companies understand that foreign investment coming from the European Union is coming, but only with these standards, and that the companies who comply with it are the ones that are getting reward, then local companies will also follow suit. We'll have, of course, scenarios as usual where they will try to skip the norm, but the standard is more important, especially when the effects on companies at European level is to keep them out of the European market, and this is one of the most important markets in the world. Okay, and I'll close it here. This is just for me to speak about the supply chain. For example, we have the Colombian Amazon. The adverse effects usually come due to lack of effective control on the supply chain of the extractivist companies. For example, illegal gold ends up being laundered and used in the US or in Europe as a product. So to conclude, at this point in Latin America, we as countries, we also have to start promoting our own due diligence law, and that the impulse from the European Union with this legislation and international standards can be an important step that could motivate us in Mexico, in Colombia, and Latin America to continue with this process and make progress in terms of companies and human rights. Thank you so much, Laura. It was a wonderful presentation. And thank you for your lessons on justice and reparation. What you're saying is right. EU legislation, if it's a good law, it can become an example for other countries and regions. That's an important message that we're also trying to disseminate. Another interesting thing you've mentioned was the pandemic. This is making things worse in Colombia regarding human rights violations by companies. And I think that in the debate at EU level, this is another argument that companies will have to discuss, because they've been affected by the pandemic. And now they will have additional mandatory standards in terms of due diligence, so they might use the pandemic also as an excuse. Anyway, now, after these interesting presentations with so many different aspects, I'd like to ask Hilimet, who is an MEP of the Greens of the European Parliament, to react and share some views about the presentations that we've been listening. We have the floor now.
Muchas gracias. Buenos días.
Thank you so much. Good morning,
and I will
everyone.
switch to English now. I'm sorry for that. I'm taking class in Spanish, but still not fit enough to speak Spanish. I'm very honored and very happy to be with you, especially also as I'm chair of the delegation for Central America for the European Parliament. And what I've heard here about Argentina, Mexico, and also Colombia, it remembers me, of course, a lot of issues that I met and that I'm in contact regarding Central America, indeed. So maybe let me start with the good news, and then coming back again to the procedure where we are at the European level. Even Pascal Durand pointed it already out. First of all, there was a strong report from the European Parliament that was taken in March 2021 in order to put pressure on the coming text coming from the Commission. And this report really said we need to consider the entire value chain. So that was really positive, and that we consider not only the direct supply, but really the whole, the entire value chain. That was really a good thing. But then I come already to a little but. Hearing what's going on in Germany, you know, there might be a coalition with the liberals and the socialists and the Greens, but the liberals, they are saying that due diligence should only cover the direct supplier. So it's going to be interesting also because Germany nevertheless has a big impact also what's going on the European level. So we have really to follow up what's going on there. And I hope, I make a call already here, that the Green Germans will put enough pressure there in order that the entire value chain is considered. What is also good, what was good in this report from March 2021 coming out of the Parliament, is that it really tackles the large undertakings, so the big companies, but all the publicly listed SMEs, as well as the high-risk SMEs governed by the law of a member state that operate in the internal market. And what is interesting, so it was not only for the companies established on the territory of the European Union, but also outside, as long as they operate in the European Union. So that was also very, very strong. And then really the main idea is really, first of all, companies are held accountable, but what was said by Laura Montagno now is very wide. We should avoid that we arrive there. So what is very important is indeed also that companies have to assess what are their impacts on the social level, on the environmental level, on human rights level. So before they act, and that is also foreseen in this report, and that is good. And then it must include, of course, a strong liability regime so that we have access to judicial remedy, and also sanctions that should be effective, proportionate and dissuasive. So that is, it was really a strong report regarding the proposal of the sustainable corporate governance tax to come from the Commission. But let me come a little bit, and then I have to take a look at my paper regarding, again, the exact procedure where we are now. Indeed, so in April, Didier Reynders, that is the commissioner of juridical affairs. So he announced in April 2020 that there would be a directive on due diligence. And then immediately there was a reaction from Business Europe, who was saying, okay, this endangers really the business, the economic ventures, and is reducing, and that is really not good, saying that is even reducing the investment in those countries. So there was really, and it's still going on, a huge lobbying campaign around it. But really, I must say, personally, this shocks me. As I said, as president of the delegation of Central America, I really saw what it be in Honduras, in Guatemala, and I saw under pressure, and even the under which, especially in Honduras, where people are getting killed on the street because they are defending their land, they are defending their natural resources. But not only Honduras, could also, of course, mention Nicaragua, etc., Guatemala. So where we are now, this directive should come out in June 2021. It didn't come because there was a regulatory review board that said, okay, the assessment, the impact assessment made by the Commission is not good enough, and they have to rework on that. But that is something not so much worrying. It's happening regularly, among 30 to 45% per year. But nevertheless, it worries me because we could also think that is really behind the scene maneuvering, and it's really the private sector influencing to postpone the whole procedure. So now we are waiting for a new text. I think, as Pascal Durand also, that it still will come at the end, until the end of the year. But another worrying thing, and I say it very openly, that it is that now it's not only the Commissioner of Justice, Didier Reynders, who is who has to take care of this text, but also the Internal Market Commissioner Thierry Breton. And he's not hiding it. He was always close to industry, and he still is. So that's, for me, also a little bit worrying. Good news, and I finish maybe on the last good news, is that, or good or not, we have to be skeptical. Von der Leyen in the State of the Union now recently, she said, yes, we're going to have a directive on forced labor. Of course, this is good, but forced labor issue is only part of due diligence. So you can say, okay, that is a good thing that we have now a text coming up on forced labor, but you could also say, okay, it's again a strategy to postpone the whole text on due diligence. So let's see. But good news, just to finish, we have a lot of member states, among also little Luxembourg, where I come from, but it's also France, and as I said already, Germany. So at least 11 member states are working on a national level also on due diligence law, which is good, because then they put also pressure on the European Commission if they have ambitious text as a member state level. And that's why I said in Luxembourg, no, go on, because there the industry is saying, oh, let's wait, let's see what the Europeans are doing, and then we make our own law. And I said, no, you should put pressure on the Commission with an ambitious text, and then I hope that the Commission will react, and that we definitely will have something really strong as the report that we had in March 2021 coming from the Parliament, so that we have something strong really to protect better due diligence principle. And I really liked your intervention. So really, I learned a lot. I took quite some notes on it because I really like also the need for transparency of information. That's something, because that's the first step. We need more transparency on the information. And I think also it is very important, and it was also discussed now, to think really a lot of detail about the criteria to fulfill due diligence principle, and and also the idea of domino effect. So a lot of interesting idea I take with me. So thank you very much to the people that spoke there this afternoon. Thanks very much. I was too long, sorry.
Thank you so much, Telly, also for being with us and also giving us some inside information as you're actually at the European Parliament. So it's very interesting. So we still would like to have some time for questions. So I'm now straight away going to Mónica González and changing to Spanish. Le voy a dar la palabra a Mónica González.
I will move to Spanish. I'll give the floor to Mónica González. She is a member of the Socialist and Democrats group from the European Parliament. I wondered whether she can give us her point of view about the new due diligence legislation. Thank you. You have the floor. Thank you. Can you hear me? Good afternoon to everyone, and thank you for inviting me to react in this online event. I've learned a lot. I took many notes, and I'd like to first of all clarify that I'm not part of the due diligence commission, basically, where this initiative was thought of. I am part of the development commission, where we discuss the development and cooperation input of the union. But basically, the due diligence report is very much linked to the cooperation and development law coming from the EU, the famous INDICI, but basically it is the instrumental tool we have to develop European solidarity. I think European solidarity is very linked to the external dimension of the European Green Deal. We know that the Green Deal can not only imply a benefit for the rich 27 countries, it should also have an external dimension. And I want to highlight this because I think the due diligence project, what the Parliament does is that it takes the first step. What it does is puts pressure on the Commission so that it stops being a soft power, and we move to achieving a directive. As you know, it's taken us a long time. The OCDE reports for multinational companies date from the year 2011. Here in the Parliament, we began to work in the year 2019 as it's the Due Diligence Commission that finally launched this in March 2019. The speaker was one of our colleagues, someone from the S&D family, Mr. Walters, and I think he did wonderful work to create consensus between the Popular Party, the European Popular Party, the Greens, and the EU and the left. So I think it is a report that is coming out of the Parliament with a huge amount of support, not only the Popular Party, which was the hardest to convince, but also the Greens, with a very strong environmental agenda. So I think this due diligence legislation and the deforestation reports are asking the Commission to have an environmental framework to put an end to deforestation. It is the two great reports that are also very linked to cooperation and development legislation. And I want to stress that link with the cooperation, because in the cooperation department, we defend that it is important not only to increase the official funds to cooperation, but also everything linked to investments, and investments are linked to companies, and there's often a lack of policy in this field. So in the due diligence reform, in the 14 point, they mentioned that it is important that the coherence in policies in development of development established in the treaty should be respected. So I think it is important that the directive comes out and it includes the mention of cooperation and development. I think the time is right, because we are in the planning stage of this document. I think that it is the right time as well, because we're seeing that in Latin America, especially, and I loved Juan Carlos Flores' intervention and his defense of the participation of the local actors and also the self-representation of indigenous peoples. And I think it is there where we should stress our focus. I loved his intervention, and I loved all interventions, because I think there's been great denouncement in the case of Guapinol, the infringements of human rights in Honduras. We're trying to be as media focused as possible in relation to the violations of human rights in the Lituango area in Colombia. We are now trying to make sure that there is enough lobbying so that these new trade agreements that are now being renewed, such as the Mexican trade agreement or the Chilean one, or also the Mercosur one, might include this perspective. We want to make sure that the due diligence is approved before the treaties come out. I share with Tilly May that this is not only an issue that has to do with the Justice Commission, but it also has to do with the domestic market commission, that commission that has to give an opinion in relation to the product that we consume in Europe. So it is a very complex subject matter. I'm not a lawyer. I will not explain this from a legal perspective. I think it is essential to consider how important this due diligence project is in the area of cooperation and development, and how important it is to have binding agreements. R&D's family decided to focus on the fact that this new directive should be compulsive not only for companies of over 250 employees, but it had to reach SMEs, and it also had to imply trade unions. According to the notes I have here, the negotiations of this report that was approved in March, one of the main fights that we had between the different groups was that in general, the right wanted to not include the trade unions, but it was decided that trade unions should participate as one of the stakeholders. Thank you, Monica. Thank you very much. You need to talk to MPs that work in jury. I can give you my input on companies working in the field of cooperation, and that's it. Thank you very much. I would love to continue participating in this debate. Thank you very much. Your contributions have been great. We will now continue our question and answer session. And We've already received many questions on the part of the participants, and we have received many questions on gender. I think the gender issue might be highlighted further in this event. Women are overall more vulnerable when it comes to violations of human rights, but then there's also many courageous women who resist on the part of companies infringing human rights. I wonder what the speakers think in relation to gender rights in this context of due diligence and reparation and search for justice. Who wants to take the floor? Soledad? Would you like to take the floor? Yes, thank you very much. And I actually love the question, and I love the fact that the gender issue is now being introduced in our report and in those inter-American reports. We think this is essential. Equality and non-discrimination are one of our criteria, and we think it's one of the pillars of any democratic system, as well as one of the bases of the protection of human rights. And this is common to the inter-American system, also the universal system, and really any European constitution. And so this directive, we hope that apart from having a human rights focus, it also has a gender perspective, taking into account that anything affecting human rights in the framework of business agreements affect the different groups differently. And so we think it is essential that in the area of human rights and businesses, we also should also have an intersectional approach that includes gender and that also considers different questions of historical discrimination of different groups in the framework of the activities, of the business activities. Specifically, in our report, we summarize the various topics that have reached us and which have most concerned us. This report was published after a period of 2 years, which involved the participation of many member states, the academia, the private sector, and particularly civil society from Latin America and the Caribbean. And we received a lot of information that basically refers to the vulnerability of women in business activities. Specifically, in our report, we refer to aspects that have to do with labor rights of women. For example, we refer to the cases of women who work in maquilas in some Central American countries, where the situation of disprotection is appalling in the context of certain companies. So yes, this subject is key in order to have a human rights approach in this directive and in this whole area. Thank you, Pilar. Someone else want to respond? I think I would only mention one thing: how to preserve the idea in the various debate spaces that if there's no gender approach, there are no human rights guaranteed. They are two concepts that go hand in hand. If there's no gender perspective, there is no guarantee of human rights for women. Thank you, Laura. So if there are no more responses, we will move to another question that we received during the event. It has to do with the topic that you mentioned, Laura, that your roundtable works on, the UN binding project on businesses and human rights. I think we might mention this more in this webinar because it is a parallel process, but it needs to complement the EU due diligence legislation. So how do you see this link between the Treaty of the UN and the EU due diligence legislation? I'd like to see the treaty in comparison to other treaties wherever there's an agreement that's ratified and accepted by countries, there still needs to be national legislation. So I think that in the case of businesses and human rights, it's very curious because the opposite is happening, i.e. countries are first legislating nationally, if you like, on businesses and human rights, and that could be putting pressure on international organizations so that there is a binding treaty. Binding treaties take a long time to materialize, but we still don't know where that binding treaty will be finally accepted. And I think all these national experiences and the fact that the EU as a bloc is also generating this debate and recognizing the relevance of the issue of human rights in businesses, I think all that will lead to a treaty that will create a minimum standard that all national due diligence legislations should comply with. I think it will be interesting how this inverse dynamics will continue. It's interesting to see how at a country level there's been developments at due diligence level, and it will be interesting to see how that is reflected on a treaty that will create a minimal umbrella that will allow for the world interpretation of national laws, which are currently happening already. Thank you. Thank you. Maybe one of the EMPs would like to react on the role of the EU in these negotiations? Or maybe not. Yes. If no one wants to reply, I'd be happy to do so. I think that we're in a situation in the EU where almost everything is being discussed in the Council, and at the Parliament what we do is boost anything that comes out of the Council. And yes, this report published in March has a gender perspective, but I think that the problem and hence our need for your work, there's a need to lobby and put pressure because there's a problem in the Council with some countries that want to have nothing to do with it, and decisions in the Council need consensus. So in a way, we need to change the rules of the game so that we do not find ourselves with a systematic blockage on the part of the Council in all these issues. Thank you. So I will now mention another question we received in the chat. Will this legislation include a reference to the energy transition process? I think it's a very current question because in the global north, we are moving paradigms in energy legislations, but this will require different extractive processes in Latin America and the world. In the case of lithium, for example, and this can cause an impact on the different territories that will add up to the territories that are already facing problems. Is it possible to have a fair energy transition debate? This will be clear and key for the region. Who would like to answer this question? If you like, I can do a brief comment on this. In a business context, it is important to recognize the sectoral impacts, and particularly important to understand that the businesses dynamics cause impacts, the greatest impacts on human rights. So when we talk about a law, the legislation as such does not have impacts. It is the actions underlying that have impact. So the extractive sector is very different to the energy sector, and separating both is very hard because the extractive sector and the energy sectors are self-dependent. And so in the case of this question, the law basically should aim at seeing what are the business dynamics, because if there's something common between all these sectors is that there are supply chains, there are employees, there are contractors, there's different protection levels for employees and contractors, there's third parties, and then there's also communities that might be impacted regardless of the sector, or and there are impacts that can be beneficious or not, i.e. positive and negative impacts. And so it is very important to see check what are the impacts and how to make a differentiated sector level range of impacts, and this has to do with implementation. And as civil society, what we can do is really important, because we have previously identified which are the impacts, and we can also communicate this, and from that on we can create implementation routes for the different sectors. So in due diligence in energy, in renewable energy sector, or in lithium, or in any other sector we might consider. Thank you, Laura. Anyone else wants to respond? Yes, thank you, Juan Carlos. If you allow me, I think it is very important to make a review by sector, and because obviously there is no balance between commercialization, say, of the electric industry and the environmental impacts and the generation of global warming, as it was mentioned by one of the speakers at the beginning of this webinar. And these have to do a lot with the environment. So it is essential that in this due diligence legislation, thinking about sustainability and the environment, it is important that the mega projects are assessed in terms of, say, metal extraction, natural gas extraction, or as was mentioned earlier on, and in Mexico and many other countries, the energy sector also generates speculation, and it is often mentioned as one of the pretexts for other types of benefits, such as, for example, the natural gas market, i.e. we will generate electric energy, but what they want is to create infrastructure for the consumption of natural gas. And in this energy transition, it is, the use of this natural gas pretext is very questionable, because it is not a clean energy, and it is being sold as a clean energy. And in this process, human rights are being infringed in a very aggressive manner, and this has been happening for decades in some places in Mexico. These markets are only being now generated, and there's been a systematic violation of human rights that will go on for another 20 years, and the utility and the need of these projects should also be put on the table and questioned in that balancing of whether they should be carried out or not.
Thank you. I'll give the floor to Soledad. Thank you so much. This is a very important topic. I think it's a key topic. And I totally agree with what Laura and Juan Carlos have just said. In this sense, I think that the topic should be there, also thinking about how any activity, especially those that are there to mitigate climate change, have also focused on the protection of humans and of nature. And indeed, the solutions to the current climate crisis cannot go back to the same mistakes that led us to the situation. If we're trying to overcome the current system, then we have to include all the rights that might be affected by corporate activities and that lead to these contexts. Once again, I think that this piece of legislation has a very important role to play in terms of protecting human rights and protecting the environmental rights and against climate change. So we hope that this is also included in the instrument that is finally adopted. Thank you very much, Soledad. We're coming to the last question. We have a lot of people who are listening to us from Latin America. I think that this is a very interesting question. What kind of routes do you recommend for Latin American organizations so that we can join efforts that have an impact on due diligence legislation everywhere? Maybe one of the MEPs can give some hints about how the civil society can do this. Tilly?
No, my hand was from before, but that is that's no problem at all. I can also react to this one. No, I think it's very important. We talked already about trade agreements, but if we would respect already also what is in the ILO principles, and that we consider always when we are companies are implementing somewhere to talk with the people who live there. And I know in Central America, and I think it's not different in general in Latin America, where people cannot always prove that the land belongs to them. And so it's important to have those exchanges really and to inform the people what's happening there. And then on the criteria for due diligence, I think events like you doing today, of course, help that we have this exchange and this input from different perspectives on what should be the criteria and the principles and the procedures regarding due diligence. So it's very important to have these encounters, to have this exchange. And I always say it's not about giving lessons one to another, but it's really on eye level to exchange the experience. And as I said before, we take a lot with us also for the legislation initiative when we talk together. If I have time, I would say something on the question before, but I see my colleague also raised her hand, but if there is some time, I could also say something on a fair ecological transition when I raised my hand before, but it's not a problem. I give first the floor to my colleague, if there is time still for that afterwards.
We have very little time left. So I'm giving the floor to Monica before I'm going to present the recommendation of the EU-LAC group, because that's also very important.
Just briefly, I think that Latin America has a lot of experience in civil society organizations, unlike any other region in the world. They're very close to European values, and those are civil society organizations in Latin America. I am Latin America, and I know how this works. So it is us who have to do not just the loudspeakers of these organizations, but to help fund these organizations from development aid instruments and everything that has to do with governance and sustaining these activities. In the EU, we work with umbrella organizations that are present today, and through them, we have direct impact. I was speaking about the defenders of Jomao and Guatemala, the Cauca in Colombia. I'm just mentioning two of the many examples that we've had. So we should continue working like this. Thank you. Thank you, Monica. We'll now give the floor to, we're going to see the recommendations of the EU-LAC group in terms of justice and reparation and the new EU legislation. Let me share my screen now. Just give me a second.
¿Pueden ver mi pantalla?
Can you see my screen now?
No.
Nope.
Okay. Lo voy a hacer de otra manera.
Okay, so let me try something else. Ahora sí. Now you can see it, right? Okay, so recommendations. Let's go to item number 1. Legislation should ensure meaningful and effective participation of the affected parties. Item number 2, companies should incorporate due diligence into their overall business structure in a way that regulates their actions. Item number 3, legislation should cover all types of sectors and companies of different sizes, including financial institutions. Item 4, the EU and its member states must ensure strict application of the law and put in place effective judicial mechanisms for access to justice and reparation for the victims. Item 5, the development of legislation must be holistic, based on legislative coherence and political commitment in the set of institutions, bodies, and agreements promoted by the EU in external action and trade agreements. Item 6, the EU and its member states should combine the introduction of due diligence legislation with reforms of trade and investment agreements, eliminating the investor-state dispute settlement mechanism to limit the ability of some corporations to undermine the new legislation. So before we close this event, I'd like to thank you so much, and thank Soledad, who has been with us today, Laura, Juan Carlos, Tilly, and Monica. Pascal as well. We'll send him a message of gratitude. It's been a great debate. I think it was interesting, with so many points that we can take back to our work when the draft is about to be published, so we can incorporate all this in our work. I'm sure that we will establish connections and alliances after this. So thank you so much to all participants for being with us. And I wish you all the best with the work ahead. Bye-bye.
Gracias. Adiós.
Gracias.